Proceedings on the return of citation on the executor guide of how to conduct your estate. Proceeding on return of citation 29. Administrators, the administrator with the will annex shall suspend all proceeding in relation to the estate of the testator, except the collection and recovery of money and payments of debts until decision shall be had. Citation. The citation shall be personally served at least 14 days before the return day. If any legatee's name be menaced, the surrogate will appoint a special guardian for them, and proof will be taken as if no proceeding had been had before on the same will. If if on the hearing of the surrogate shall decide that the will is for any reason invalid, or that it is not sufficient proved to have been the last will and testament of the testator, he shall annul and revoke the probate thereof. If otherwise, he shall confirm such probate. His decision may be appealed from at any time within 3 months therefrom. Whenever the surrogate shall annul the probate, he shall cause notice thereof to be served on the executor name in the letters, or the administrators with the will annex, and to be published for 3 weeks in a newspaper printed in the county. The power of authority of the executor and administrator with the will annex shall thereupon cease, and he shall account for all money received by him, but all acts done in good faith before notice shall be valid. 30. Of granting letters testamentary, the reunion creation of executors, letters of administration with the will annex, how executors compelled to give bonds. After a will of a person, estate shall have been proved, the surrogate will issue letters testamentary thereon to any competent person named as executor who shall appear and qualify, and they be granted immediately unless some person instructed file affidavit that he intend to interpose objection to competency of the executor under the previous quote hereunfor on page with C. If such affidavit shall be filed, the surrogate shall stay the granted of letters for 30 days unless the matter shall be sooner disposed. S.L. 1837, Chapter 4, 6022, 3.R.S. 5th edition 154. See affidavit objection of order in appendix. If the affidavit shows any intention to file objection against only one of the several executors, the surrogate will suspend action as to all. McGregor versus Bureau, 24 new dot y dot 166. The affidavit shows any intention to file objection against only the one of several executors. If the objector swears that he is the creditor, the surrogate will not try to issue as to whether he is. 31. In fact, the creditor but will try the objection. Estate Harder in Ferris 1 Tucker 15. As to the rules of adjudication upon the objection, see hereafter he regarded request executors to give bonds after letters issued. And letters will be issued on the executors qualifying or taking the oath of office and filing the same with the surrogate. This oath may be taken before the surrogate, county judge, commissioner of deeds, or the clerk appointed by the surrogate. In Kings County, the clerk of clerks of the surrogate are also authorized to administer it. See Form Appendix 3R.S. 5th edition 171, S.L. 1863 / Chapter 392 9. Any person named as an executor may renounce by instrument in writing, attested by two witnesses, and on the same being proved to the satisfaction of the surrogate, he will file and record it. See form in appendix. And if any person named as an executor shall not appear to qualify within 30 days after the will is proved, and shall not have renounced, the surrogate may, on application of any person interested, issue a summons to such executor to appear and qualify within certain time, or he will be deemed to have re-announced the appointment. See pension and in appendix 2R.S.73 R.S. 5th edition 155. But if all the persons named as executors renounce. 32. Or neglect to qualify after summons as above, all above legally incompetent, then letters of administration with the will annexed will be granted, as if no executors had been named in the will. Number one, to the residuary legatees or some one of them. Two, to any principal or specific legatees, to the widow of the next of kin, to any creditor of the testator, and in the same manner and under the like of regulations of restriction as letters of administration in case of intensities, which see hereafter. See pension order, etc. in appendix. A guardian of an infant who is not residuary of specific legatee is not entitled to letters with the will annexed in preference to the widow of the testator. Clavet versus Mattis, 43 bar 417. An executor who does not reannounce or who is not deemed to have reannounced after summons may at any time appear qualified, and letters will be issued to him, and in some cases it is advisable to apply for such letters, either for the protection of the estate or when the executor previously acting shall die or become incompetent. An executor who has renounced may retract his renunciation at any time before letters are issued to others or others afterward upon the decease of those having letters or after their revocation. Robertson versus McCoy, 11p 640. Casey versus Gardiner, 4 Brand. Letters testimony upon a will of testator. 33. Domicile without the state at the time of death may also be issued by the surrogate of any county in which there may be any property effect. C.S.L. 1863, 694. If after letters testimoniary shall have been granted to any person named as executor, complaint shall be made to the surrogate of the county by any person interested in the estate that the person so appointed as executor has become incompetent by law to serve as such, or that his circumstances are so precisely as not to afford adequate security for his due administration of the estate, or that he has removed or is about to remove from this estate. The second shall proceed to inquire into such complaint as an incompetency, see above 12. The executor has no property except an unliquidated demand, and it was about to remove from the estate, held that it should be required to give security. Wood versus Wood, 4 page 299. Holmes versus Clark, bar 6. Executor should not be required to give security merely because he does not own property to the full value of the estate, and when there is no ground for supposing that the trust fund is in danger. Mandeville versus Mandeville, page 475. The main point is whether the circumstance being considered it is doubtful rather than trust.